please settle down?
Gut, wir kommen nicht zum H&M, aber sonst welche hätte ich schon, oder?
Thank you. We shall now begin the second session of this morning, in which the country delegates will share lessons learned from their own work in juvenile justice systems and share with us their experiences, and I would add, if they can help us, to also address some questions that they find emerging in their implementation of the juvenile justice law in their countries, the challenges that they face, and the ways they feel they can overcome them. So I shall call upon, as the first speaker this morning, His Excellency Mr. Pascal Barandigagie, Minister of Justice of Burundi. He's been a lawyer and he's also been a judge since 1997 and a minister since 2011. The floor is yours, sir. Just to let you know the rules, you have 20 minutes. At 15 minutes, I'm going to start flashing this paper, letting you know that you have 5 minutes more, then at 2 minutes, and then a time up paper. I'm sorry, it's going to be rude, but that's the only way I can keep the time. Thank you.
Excellences, Mesdames et Messieurs, chers participants, tout protocole respecté, je voudrais saisir cette occasion pour remercier au nom du gouvernement du Burundi et à mon nom propre la Confédération suisse et la Fondation Terre des Hommes pour l'invitation qu'ils nous ont adressée afin de participer dans cet important congrès mondial sur la justice juvénile. Bien plus, c'est un grand plaisir et un honneur pour moi et mon pays, le Burundi, de prendre la parole devant cette auguste assemblée pour vous présenter la réforme qu'a connue notre système de justice juvénile pratiquement sur une période de plus de 10 ans, c'est-à-dire que nous prenons ici comme repère l'année 2000 qui coïncide dans mon pays avec la fin de la guerre civile qui a duré plus d'une décennie. Et je commencerai par les constats, c'est-à-dire un bref état des lieux, puis les étapes de la réforme, et je terminerai par les résultats ainsi que les leçons apprises. Bien entendu, et je ne prétends pas nullement être un spécialiste de la justice juvénile, mais plutôt beaucoup plus en administratif, en décideur politique. Ainsi, l'intérêt de ma communication, et c'est vraiment mon souhait, c'est que l'auguste assemblée, en général, et en particulier mes collègues de l'administration, puissent intérioriser en termes de leçons apprises, et c'est ça le thème central de la communication, l'importance de 3 aspects essentiels à toute réforme dans ce domaine. Primo, la volonté politique de mieux protéger les enfants. Secondo, l'implication et la collaboration de toutes les parties prenantes, c'est-à-dire le gouvernement, les partenaires techniques et financiers et la société civile. Tertio, la formation des acteurs clés. Et je vise ici tous les professionnels de la chaîne pénale. Et je crois qu'un des orateurs y avait beaucoup insisté. Et je crois qu'il s'agit d'un orateur suisse, M. Jean Zermatten, que je félicite beaucoup. Et donc, les 3 aspects, pour moi, sont des aspects assez importants dans toute réforme. Et comme vous allez le voir dans ma communication, je vais chaque fois y revenir. Comme je le disais, je vais commencer par les constats. Le premier constat, c'est que si l'on considère l'année repère 2000 et là où nous en sommes aujourd'hui, il y a un contraste assez énorme. Et comme je vous l'ai dit, le Burundi a signé en 2000 les accords de paix d'Arusha qui mettront fin à plus de 10 ans de guerre civile. Et en 2000, il y avait vraiment obscurité juridique totale en ce qui concerne la justice juvénile. Ça veut dire que la justice pénale de l'époque ne prenait pas en compte la spécificité des enfants et donc inadaptée aux besoins des enfants. Il a fallu un travail assez énorme, une réforme importante que nous avons initiée depuis lors. Et depuis cette période, on peut dire qu'aujourd'hui, en 2015, notre système de justice juvénile est une justice restauratrice qui va vers une conformité aux exigences de la Convention internationale des droits de l'enfant aujourd'hui. Quelles sont cette fois-ci les étapes de cette réforme? La réforme que nous avons initiée depuis 2000 est essentiellement basée sur 3 axes importants. D'abord, la réforme du cadre légal. Ensuite, la mise en œuvre des mesures d'accompagnement. Et enfin, la formation des acteurs de la justice juvénile, restauratrice, y compris les assistants sociaux. Tout a commencé par une table ronde qui s'est tenue les 20 et 21 mai 2002. Et la table ronde sur la justice pour mineurs qui a regroupé tous les intervenants dans le domaine. Et juste après cette table ronde, le ministère de la Justice et tous les partenaires ont décidé de tout mettre en œuvre pour assurer une protection des enfants en conflit avec la loi, en accord avec l'exigence de la Convention internationale des droits de l'homme, convention ratifiée par le Burundi le 16 août 1990. Juste comme conséquence de la table ronde, on a, après coup, assisté à une série de formations. On en enregistre plus d'une dizaine. Les formations, les ateliers de formation qui se sont suivis et qui ont concerné tous les acteurs sans exception de la chaîne pénale. On va aussi observer comme conséquence l'intégration de la justice pour mineurs dans la rédaction du nouveau code pénal. On est ici en 2008, où on commençait à discuter, on commençait à faire les travaux préparatoires du code pénal qui est finalement sorti en 2009. Permettez-moi encore une fois de revenir sur un aspect concernant les formations. Un orateur de ce matin les a qualifiés comme un agent du changement et je voudrais donc profiter de cette occasion pour soutenir cette affirmation. Et chez nous, à raison de ces formations, on a aussitôt remarqué des avancées importantes dans ce domaine. Et je dois vous dire que, à raison des formations qui ont été faites à l'endroit des acteurs de la justice, on a observé des pratiques qui ont même dévancé la mise en place des lois, ce qui est assez important. Même en l'absence de loi, on a initié de bonnes pratiques au niveau de la procédure en faveur des mineurs. Et entre autres, on peut mentionner ici la réduction de la durée des peines et de condamnation à l'endroit des enfants et l'octroi plus fréquent de la liberté provisoire. Il y a aussi lieu de mentionner à titre de bonne pratique la présence tolérée de l'assistance sociale dans la procédure, à la police d'abord, puis au tribunal, ensuite, et ça sur demande de l'avocat en charge du dossier. Et tout ça se faisait en l'absence d'un texte légal, seulement à titre de bonne pratique tolérée. On peut aussi citer l'organisation des audiences spécialisées pour les enfants, et ceci a commencé de l'année 2007. Et jusqu'ici, le cadre légal n'était pas encore mis en place et était toujours inadapté à la justice restauratrice. La suite de la réforme va s'articuler autour de réformes structurelles importantes. C'est ainsi que, le 22 avril 2009, une modification conséquence du cadre légal est intervenue avec l'adoption du code pénal en vigueur jusqu'à aujourd'hui, introduisant pour les enfants des dispositions nouvelles, plus conformes aux principes édictés par la Convention internationale des droits de l'enfant et renforcées encore par la promulgation du nouveau code de procédure pénale en vigueur depuis mai 2013. Et seulement à titre d'illustration, permettez-moi de vous dire quelques innovations apportées par ce code. Je dis bien quelques innovations. Il y a lieu ici de signaler la responsabilité pénale qui passe de 13 à 15 ans. On peut aussi citer la suppression de la peine de mort. On peut aussi citer et surtout l'introduction des peines alternatives à l'emprisonnement et en l'occurrence le travail d'intérêt général qui est vraiment recommandé et surtout en faveur des mineurs. On peut aussi citer l'introduction ou plutôt l'amélioration du système des excuses qui vont faire que lorsque un enfant, donc un mineur, a commis une infraction où il devait être condamné à perpétuité s'il était adulte, cette fois-ci, le code édicte que l'enfant est condamné à une peine qui va de 5 à 10 ans. Et lorsque, ça c'est l'article 29 de ce code, et lorsque l'enfant devait écoper d'une peine de servitude pénale à temps, la même disposition nous dicte que l'enfant ne peut écoper d'une peine qui va au-delà de 4 ans. C'est donc une avancée par rapport à la législation antérieure. En ce qui concerne le nouveau code de procédure pénale, celui-ci a introduit la notion d'assistance obligatoire des mineurs dans toutes les phases de la procédure. Ce qui fait qu'aujourd'hui, tous les mineurs doivent être assistés par un avocat. Et ensuite, le code a aussi introduit la notion d'assistance sociale qui doit aussi être du côté de l'enfant dans toutes les phases de la procédure, y compris, bien entendu, la notion de prise en compte de l'intérêt de l'enfant dans toutes les phases de la procédure. Donc, c'est seulement à titre illustratif. La réforme a continué en 2010 avec la création de la cellule nationale de protection judiciaire de l'enfant au sein du ministère de la Justice. Cellule chargée de la mise en place du système de justice pénale spécialisé pour les enfants. En 2011, il y aura l'adoption de la politique sectorielle 2011-2015 du ministère de la Justice et qui fait comme expression la volonté politique qui déclare la justice pour mineurs secteur à part entière de la justice au Burundi en intégrant dans la coordination du ministère de la Justice un sous-groupe thématique justice pour mineurs en charge de la mise en œuvre de cette nouvelle thématique. Et c'est au sein de ce groupe thématique que les agents du gouvernement se rencontrent avec les partenaires techniques et financiers ainsi que la société civile pour discuter des avancées qui doivent être respectées en termes de justice juvénile restauratrice. Et depuis 2009, on va constater que plus de 1000 acteurs de la justice ont été formés sur la justice pour mineurs. Il y aura aussi ouverture début 2015 de 2 centres de rééducation pour mineurs. Je crois que d'ici le mois de février, les 2 centres pourront être ouverts et ce sont des centres où les mineurs en conflit avec la loi pourront être regroupés, on va leur enseigner les métiers et naturellement les mineurs qui étaient à l'école pourront continuer à étudier et naturellement même s'ils auraient commis une infraction. Et nous pensons qu'il s'agit là d'une avancée pour nous assez significative. Nous sommes aussi en train de finaliser le code de protection de l'enfant et nous pensons que d'ici 3 mois, ce code pourra être promulgué. Cette fois-ci, quels sont les résultats de la réforme que nous venons de relater les grandes lignes? Comme je le disais tout à l'heure, nous avons assisté à une augmentation de 2 ans de l'âge de la responsabilité légale qui est passé de 13 à 15 ans en 2009. On constatera aussi que le nombre d'enfants en conflit avec la loi qui sont détenus dans les prisons du Burundi a baissé de plus de 60% en 4 ans. Donc, ce nombre est passé de 440 détenus mineurs en janvier 2011 contre 160 au 31 décembre 2014. On constatera aussi que la durée de la détention préventive a baissé de 14 mois en 5 ans, en passant de 88 semaines en 2010 contre 32 semaines en 2014. Et quelles sont cette fois-ci les leçons apprises de cette réforme? D'abord, la prise en compte de la spécificité de l'enfant et de ses droits consacrés à travers les principes fondamentaux de la Convention internationale des droits de l'enfant, bien compris grâce aux formations reçues dès 2002, a été un fort vecteur de pousser vers les changements progressifs de la pratique d'intervention des acteurs. La bonne compréhension produit donc l'action. Ensuite, nous allons tirer la bonne leçon que la formation a été une activité déterminante pour les acteurs qui, même en l'absence d'un cadre légal adéquat, ont pu commencer à introduire des pratiques bénéfiques à l'élaboration d'une réforme favorisant l'adaptation du système de justice pénale aux besoins des enfants. On aura aussi appris que le système de justice juvénile a pu se construire en progressivité à partir de l'existant, avec le choix intelligent d'axer les innovations sur les règles de la procédure et le savoir-faire des acteurs. Il n'est pas besoin de tout avoir pour commencer à agir. Telle est l'autre leçon que nous apprenons de cette réforme. La progressivité dans l'action est un atout pour avancer durablement. Et enfin, comme leçon, la réussite de la réforme du système légal est aussi due à l'intervention de partenaires venus s'allier à l'effort entamé par le gouvernement. La synergie des acteurs est un facteur de succès pour le renforcement d'un système de justice pénale spécialisé pour les enfants. Pour conclure, nous disons que grâce à une forte volonté politique, à une réforme du cadre légal, à la synergie des acteurs et à un important investissement dans la formation et la sensibilisation, le système de justice juvénile restauratrice au Burundi est aujourd'hui une réalité. Cette amélioration de la prise en charge des enfants en conflit avec la loi s'est faite progressivement à partir de l'existant, avec le choix intelligent d'axer les innovations sur les règles de procédure et le savoir-faire des acteurs, d'une part, et avec une option d'un meilleur usage des alternatives à l'incarcération et de faible investissement sans composante infrastructuraire trop coûteuse. Ainsi, il n'est donc pas besoin de tout avoir pour commencer à agir. L'expérience du Burundi montre que la progressivité dans l'action est un atout pour avancer avec efficience et surtout de manière durable. Vive la justice juvénile restauratrice, vive l'avenir de nos enfants. Je vous remercie. Et j'ajoute que l'essentiel de la communication est logé dans ce petit fascicule. Et on en a quelques exemplaires à distribuer. Et aussi, on peut retrouver tout ce qui concerne la justice restauratrice au Burundi sur le site du ministère de la Justice www.justice.gov.bi. Merci encore une fois.
Thank you, Your Excellency, Mr. Pascal Barandagie. I shall now call upon Her Excellency, Madame T. Sulukiani. Have I got that right? She is the Minister of Justice from Georgia. She has been a practicing lawyer and a judge of the European Court of Human Rights and has been minister since November 2012. The floor is yours, Madam.
Distinguished delegates, ladies and gentlemen, it's a privilege for Georgia to participate in this World Congress on Juvenile Justice and to be here with you today. I'm very thankful, therefore, to the government of Switzerland as well as to Terre des Hommes and the whole team present here who made this Congress possible. The World Congress on Juvenile Justice could certainly become a milestone in the implementation of different international norms in the field of juvenile justice, as long as sharing good practices and learning from each other's experiences. And this is in the interest of international community at large. Let me now share with you Georgian experience in the process of reforming the juvenile justice system. Reforming this system has been one of the top priorities of the government of Georgia over the last 2 years. I should share with you that repressive and punitive approaches in criminal justice in general, including children matters, dominated the minds of the Georgian politicians and law enforcement agencies throughout the Soviet era, and not only. It was the case even after the downfall of the former Soviet Union, and this until very recently, 2012. It was wrongly believed that the only way to reduce crime rate on behalf of security, fight against criminality, was to toughen the criminal policy. Such exclusively repressive thinking manifested itself in the so-called zero-tolerance criminal policy towards inter alia children in conflict with the law, which eventually led to no significant results in the country other than placement of Georgia in the top 5 countries in the world in terms of the number of prison population. The incarceration rates for juveniles increased accordingly. In 2008, the number of convicted children reached 1,100 as opposed to 300 today. In October 2012, we made a U-turn in criminal law policy and embarked on overall liberalization of the criminal justice system, including that of children. A number of preventive programs have been introduced and are being implemented by various state agencies, including the Ministry of Justice and its Crime Prevention Center, the Ministry of Corrections, Ministry of Foreign and Internal Affairs, Chief Prosecutor's Office, Ministry of Health, and Ministry of Sports and Youth Affairs. Alternatives to judicial procedures, such as mediation and diversion, are being actively referred today by the relevant authorities. Individual sentence planning is currently applied to each child in the juvenile correction institution. The number of psychologists and social workers has been increased also, and they have been trained based on new training modules adjusted to the individual sentence planning scheme, which is designed to reduce existing risks and prepare the child for reintegration in the society. Currently, each child convicted has an access to education, sports, social and professional skills development programs, and the majority of them are taking part in vocational training courses and sports activities held in juvenile rehabilitation establishment. Some drastic changes to the criminal procedure code leading to real adversarial trial, transparency and equality of arms were also enacted last year as required by Article 6 of the European Convention on Human Rights. Although all these new approaches in the juvenile justice system have been actively implemented in practice in Georgia, in the recent years, there has been no separate criminal law for children. That's the reason for which the topic of my speech today is the Juvenile Justice brand new code, which has just been drafted with the help of different partners. And I would like to take this opportunity to thank UNICEF and Judge Renate Winter present here for this work. In 2013, actually, as a Minister of Justice of Georgia, I thought and publicly stated that Georgia needed a separate code regulating all aspects of juvenile justice and decided to create a working group with this mandate. As mentioned, the Ministry of Justice, in cooperation with European Union and UNICEF, have just finished to draft the new code, and a number of important international instruments regulating juvenile issues were taken into consideration in this process. Geneva Declaration, United Nations Declaration on the Rights of the Child, different rules, Beijing rules, United Nations rules for the protection of juveniles deprived of their liberty, European conventions, and other international model laws and practices. It's noteworthy that the existing criminal law in Georgia, to a certain extent, it's true, does provide some specific approach for juvenile offenders. However, international standards are much higher, and existence of a single legislative act on juvenile justice is undeniably necessary. As we all know, a single juvenile justice law simplifies matters by enabling all role players involved in the juvenile justice process, such as the police, prosecutors, judges, legal aid providers, financed by the state budget, professionals working with children, and the general public, to find, read, and understand one comprehensive piece of legislation rather than a number of different pieces of various laws. Our draft Juvenile Justice Code, which will be adopted, I do hope, by Georgian Parliament in spring this year, defines criminal and administrative responsibility of juveniles, special features of criminal proceedings involving juveniles, special rules for execution of sentences, etc. The Code's overall objective is to fully incorporate into the law the best interest of a child and other principles of juvenile justice enshrined in the relevant international documents, including but not limited to ones aimed to expand the alternatives to criminal prosecution and diversify the sanctions available to the judge, to provide for the resocialization and rehabilitation of juveniles in conflict with the law, and to ensure that detention and imprisonment are used only as measures of last resort against juveniles. The Code also aims to protect juvenile victims and witnesses, and at the same time to prevent reoffending and protect public order in the process of administration of justice. The key principles are as follows. First of all, the best interests of a juvenile shall be considered. As mentioned by many here before me, any measure taken against a child in conflict with the law must be proportionate to the committed act, should be relevant to personality of a juvenile, and correspond to his or her educational, social, and other needs. In all cases, priority shall be given to alternative measures while using imprisonment as a last resort. Juvenile justice procedures shall be administered only by professionals specialized in juvenile justice, mediators, social workers, judges, prosecutors, investigators, and others who work with juveniles in conflict with the law, as well as juvenile victims, and witnesses must go through special trainings. Participation of a juvenile at any stage of legal proceedings will be guaranteed by law, and juvenile justice procedure will be conducted without any unjustified delay, and time limits under the Juvenile Justice Code are much shorter than in the adults, so-called the adults criminal code. In any decision-making process, an individual approach will be applied to each child. This means that individual circumstances of the child, such as age, level of development, conditions of his or her life, upbringing and development, education, state of health, family situation, and other individual circumstances which allow evaluation of personality, behavioral features of the child, and determination of his or her needs shall be taken into consideration. In addition, apart from refining and accumulating provisions on juveniles from the various legislative acts of Georgia, the draft code also provides some brand new approaches for us, such as applying the code Juvenile Justice Code to administrative offenses, introducing the notion of young adult offenders, and immediate expungement of criminal record in accordance with European rules. In accordance with these standards, the draft code proposes, for instance, that the criminal record for the child is expunged from the moment the sentence is executed. Article 12 of the draft code guarantees the right to privacy of a juvenile at any stage of justice proceedings, and the information about criminal record of the child should be considered as confidential, and personal data of juvenile should not be disclosed or published in any way. This confidentiality principle has a vital importance for effectiveness of a resocialization rehabilitation process and for assisting the person to reintegrate with the society as a valuable member, allowing them the chance to forget. But by contrast, disclosing information on a juvenile's criminal record can create serious difficulties for a juvenile in terms of starting a new life, finding a job, for instance. As a result, it creates a risk of reoccurrence of a crime and stigmatization. Hence, keeping juveniles' criminal record confidential is in the interest of the community in general as well. In conclusion, I should underline once again that repressive and punitive approaches in the criminal justice in Georgia, including in juvenile matters, dominated our minds since the Soviet rule and until very recently, 2012. But the present Georgian government's policies, strategies, and action plans in criminal law, including children, are aimed at the liberalization of criminal law and practice, and to show that fighting criminality can also be about prevention of crime. And their policies' focus have been shifted to prevention, early intervention, and rehabilitation. In recent years, a number of preventive programs have been implemented by various state agencies in close cooperation with international and local partners. In addition, substantial attention was paid, as I mentioned in the beginning, on non-legal alternatives for judicial procedures such as diversion and mediation. Diversion has been in use for 4 years now in Georgia, and during the last 2 years, 300 children were diverted a year, which is 51% of offender children, as opposed to 80 children in 2011, and this figure is growing with years. Only 8% out of those diverted children reoffended, which makes me to believe that this program is successful and worth continuing. That's why, if the diversion program has been until now regulated only by the ordinance of the Minister of Justice of Georgia, we offered the diversion a special and particular place in our draft Juvenile Justice Code. In the context of rehabilitation and reinsertion of juveniles, important steps were taken to reduce the number of custodial sentences and significantly improve prison conditions. In November 2012, 130 children were in prison. On 1st of January this year, they were 80. Pretrial detention was applied to 300 children in 2010, whilst this number was 70 last year. In 2011, 700 children were convicted, as opposed to 300 last year. These figures, the practices, new approaches, and the draft Juvenile Justice Code, as well as other reforms implemented by the government in the area of juvenile justice, are perfect proof that between punitive and preventive approaches, we gave priority to the latter. Our government and the Ministry of Justice of Georgia remain convinced that this approach will positively affect juvenile justice system at large and prove to be an effective policy in the following years. Thank you for your attention.
Thank you, Your Excellency. May I now call upon Mr. M.A. Jinmin, Deputy General Director of Department of Treaty and Law, Ministry of Foreign Affairs, People's Republic of China. You heard him yesterday too.
Thank you, Chair, for your introduction. Excellencies, distinguished delegates, ladies and gentlemen, I'm honored to speak here today. The theme of my presentation is Key Features of the Juvenile Justice System in China. In 1984, the first Chinese juvenile curling panel, the May 10 form of China Juvenile Justice System, was established in the court of Changning District in Shanghai. Over the last 3 decades, China has gradually put in place a unique juvenile justice system of its own in the light of the national conditions, while learning from international experience. I would like to share with you the Chinese juvenile judicial justice system from a legislative and practical perspective. First, we have set for ourselves the fundamental concept and the legal system for juvenile justice to maximum interest of children. The legal instruments that are applicable to Chinese juvenile justice system include international rules and the Chinese domestic legislation. As for international rules, China is Part 2 Convention on Rights of Child. The Chinese juvenile justice system provides maximum protection to the juvenile of their legitimate interest in strict conformity with the Convention. Besides, China has taken major international instruments concerning juvenile justice as references for the judicial practice of its own juvenile justice system. These instruments include UN Standard Minimum Rules for the administration of juvenile justice, the UN Guideline for the prevention of juvenile delinquency, and the UN Rules for the protection of juvenile deprived of their liberty. As regards Chinese domestic legislation, the national law applicable to the Chinese juvenile justice system consists of lex specialis, namely the law on the protection of minors and the law on the prevention of the juvenile delinquency, and the lex generalis, such as related preventions in the criminal law, the criminal procedure law, the marriage law, and the prison law. In handling cases involving minors, special agencies are set up or special persons designated as may be required in view of the characteristics of the minor's physical and mental development. The principle maximizing children's interest enshrined in the above-mentioned domestic legislation as a fundamental concept and core value. The handling cases of the juvenile delinquency, the Chinese courts uphold the policy of the education, reform, and redemption, and the principle of take education as primary approach and punishment as secondary. As such, juvenile delinquency cases apply special litigation procedure no criminal offense committed by juvenile under the age of 18 shall be heard in public. In addition, special systems have been established, such as presence of qualified adults and the sealing of the criminal records of minor convicts. In handling civil cases involving minors, the Chinese courts uphold the principle that minors be given special and preferential protection and adopt the judicial concept or positive approach. Preferential treatment, approachability of loving care. Efforts have been made to develop systems of guidance in proceedings and protection volunteers so as to protect minors' legitimate interest and rights to the greatest extent. Now I move on to the second part. Second, diversify organization's mode of the juvenile justice system. In China, courts have 4 levels, namely grassroots courts, intermediate courts, high courts, and supreme courts. Courts at all levels can hear juvenile cases. There's not a single organizational mode for Chinese juvenile justice system. The juvenile justice system can mainly be divided into the following 4 modes. The first mode is juvenile tribunal, which is to hear juvenile criminal cases and civil cases involving minors. So far, there are as many as 602 juvenile tribunals established in China. The second one is juvenile criminal tribunals, which refer to those tribunals that are independent from other tribunals and only deal with juvenile criminal cases. Up to now, there are 405 juvenile criminal tribunals nationwide. The third one is juvenile collegial panels. Fixed collegial panels are set up in criminal tribunals to deal with juvenile criminal cases. So far, juvenile collegial panels totally 1,246 nationwide. The fourth mode is what we call special task force mode. In those courts with smaller number of juvenile cases and few judges, the special task force modes may be applied, whereby special task force of judges is designated to deal with juvenile criminal cases. The above 4 modes constitute a relative comprehensive network of China juvenile justice system. It is based on respective conditions of different localities. They not only meet the needs of juvenile justice, but also help to guarantee the effective protection of legitimate interests of juveniles. Third, unique trial system. The Chinese courts have established juvenile trial system and mechanism with Chinese characteristics, which are different from those applicable to adult cases. Such system and mechanism include, but not limited, the following 4 kinds. The first one is the round-table adjudication. The prosecutors, defenders, sit at one table within the minor's defendant in the proceedings. The round table hearing help to create atmosphere of understanding in order to better educate and positive influence the juvenile through joint efforts. The second one is the social inquiry reporting system. Professionalist written reports are prepared and submitted by special personnel with a background of psychology or other medical science, or familiar with characteristics of juvenile physical and psychological development, and experience in dealing with juvenile cases. Before reporting, they carry out a full investigation into the relevant facts about juvenile delinquency, and then, based on their expertise and personal experience, make a scientific analysis which should be objective, thorough, comprehensive, and fair. In the reports, they need to draw a scientific, profound, and professional conclusion on the cause of the delinquency, personal and social associated with the juvenile, and make appropriate recommendations. Such report may serve as aid for judges to decide whether to convict and what penalty to impose, taking into account lesser and mitigated punishment for the juveniles. The third one is psychological assessment and intervention. Psychological assessment shall be carried out in juvenile criminal cases. In addition, together with psychological assessments, other means conducive to bring positive psychological or behavior change of delinquent juvenile are often used as well, including psychological counseling, psychological therapy, and behavior correction. The fourth one is the probation volunteer. Chinese probation volunteers are selected and appointed from NGOs by course. The volunteers have a related work experience or professional background. They take part in the litigation process to instruct, supervise, observe, protect, and regulate juveniles so as to correct and improve their behavior and guarantee the smooth functioning of the process, which provide a basis for the court decision. Last but not least, the approach of integrating education in proceedings. Chinese juvenile justice system adopt approach of integrating education in proceedings of minors, being taken into account appropriate working methods are put in place to embody the concept of integrating education in proceeding of juvenile criminal cases through, even though criminal trial might be seen as a major setback of delinquency minors, they have to go through such approach provides juvenile with an amiable atmosphere to feel the care of the families and the communities, which prove to be the best way to educate juvenile offenders. Two key features of this approach need to be highlighted. Firstly, educating and positive influencing for better as an integral part in the trial proceeding. The tribunal actively promote positive change of juvenile through education before and during the trial, and even after the conviction. Unless juvenile defender alleged innocent after court debate, the judge of the juvenile tribunal invite not only the prosecutors and the defenders, but also the families and the relatives of juvenile defendant to joint education session and remind him about the offense, make him reflect on harm caused by the behavior, and compel him to repent. The instruction at trial turns the court into the school of home in the eyes of the juveniles. Secondly, implementing the principle of learning from past mistakes to avoid future ones, and curing the sickness to save the patient. By integrating education in proceeding, the court aims instructing the juvenile offender to recognize the dangers of their offense and the illegitimacy of the behavior, and awaken them to the importance of the law and morals, rather than investigating the specific delinquency. Many juvenile offenders cannot help tears at this stage of the trial, deeply regretting what they have done. There's no doubt that integrating education in proceedings works well in convincing the juvenile and preventing them from re-offending. In fact, China is among the countries with the lowest real juvenile refounder, as the rate of recidivism of the Chinese juvenile offenders has always been below 2% since 2002. Ladies and gentlemen, in conclusion, in the Chinese juvenile justice system, based on China's actual conditions, aim to safeguard sound growth and development of the juvenile, balancing both for justice and redemption through education. Practice of the past 30 years prove that Chinese juvenile justice system meets our needs. However, it's an ongoing process to protect juvenile legitimate interests and rights, which never end. China would like to further exchanges and cooperations with our counterparts and learn from each other, thus striving to strengthen and improve Chinese juvenile judicial system. Thank you for your attention.
Thank you, Mr. Jinmin. From all the three speakers, what came out very clearly was that all three countries saw the need to shift to a separate juvenile justice system, and the results are already obvious. As Her Excellency, the Minister from Georgia, said, juvenile justice system simplifies matters. The other important point that was made by His Excellency was the importance of the progressive approach. We probably cannot do everything at one go, but we should not stop. We should keep trying, and the beginning is the most important, and taking it step by step. The synergy between actors is something that all three of the speakers have emphasized on, and involving non-governmental actors too, and experts. The importance of speedy justice has been emphasized, but I would like to add, speedy justice is not about discount on justice, you know. on the nature of justice. So speedy justice must not be a discount on the nature of justice. The justice has to be equally important. The non-stigmatization of the young offender has also been emphasized upon, and the expunging of the reports and the long-term reintegration. There were three terminologies that I wanted to put before the House that was new, that was being used, and it was something that that at the IJJO too created a bit of discussion, and that is the three terminologies being the juvenile, the child, and the minor. Are they to be used interchangeably? Are they different? For a country like India, for example, a minor is defined differently in different laws, and a juvenile is very clearly the 18-year-old child. So these are things. These are some questions that you might wish to. The other terminology that was used was the young adult offender, which was new to me. So there are now minor, juvenile, child, and young adult offender. There are different terminologies being used, and how do the participants wish to see this? And that is something maybe the experts in their roundtable will address when they come on. If any one of you is interested to know a little bit more about India, there's a leaflet that's going around, and my colleague just WhatsApped to me to remind that please do mention that we are going through a bit of a crisis in India, because there is, and the coalitions are trying to struggle to keep the standards in place. While all the other countries are increasing their standards, we are lowering them. So we need all your support. Before we go, thank you very much for the speakers on this panel. I thank you for your presence here. Before we start on the expert roundtable, I would like to invite for just 5 minutes, Avril, Judge Avril Calder, to introduce the International Association of Youth and Family Judges and Magistrates. You only have 5 minutes, unfortunately.
Hello? Hello. Can you hear me? Very well. Good. Thank you to Enakshi for giving me these 5 minutes. I'm here, delightfully here, to stand before all of you from so many places all over the world. And I'm here as the President of the International Association of Youth and Family Judges and Magistrates. You will see in your delegate bag 2 sheets of paper. They relate to us. And I invite you to read them and come to speak to me at any point during the next 3 days, or visit our table downstairs where members are available for you to talk to in English and French and Spanish and Portuguese. As I said, we are worldwide. The other thing that I would like to say is the title of judges and magistrates may put you off a little. I want to tell you that we are open to all those professionals who are associated with children under 18 who are in trouble with the law or who are in need of care and protection. So please, if you're a social worker, a probation officer, a police officer, an advocate, a prosecutor, our association is open to all of you. And I would like to say that if you considered joining and did join, you would be joining one of the oldest not-for-profit, non-governmental organizations in the world. We started in 1911, or at least that's as far back as we have any records. So please do approach us, come up to us, talk to us, become our friends. Because in 2018, we will be having a Congress like this, and we would like to see all of you there. Thank you.
Thank you, Avril. If you've all noticed, all the legal people have blue badges and the rest of us have orange ones. So maybe then I'll get to wear a blue badge, Avril. So now can I now invite the expert panel onto the podium. Dr. Armengol Kwara Lopez, Justice Iman Ali, Ms. Christina Weber Khan. This panel will be moderated by Michel Lacher, Juvenile Justice Magistrate from Switzerland. While the experts are taking their place, I'm hoping that based on the discussions this morning from the two other panels, that the experts will address some of the remaining questions that I had raised in the first session. And most importantly, how do we successfully make a shift from guilt, the panel please, how do we successfully make a shift from guilt to responsibility to restoration? You have a very important question to address. How do we make a shift from guilt to responsibility to restoration? How do we strengthen the system on prevention, early intervention, rehabilitation? These were some of the very important questions that were raised since the morning. So here, Michelle. Yeah? Yes. Can I pass this on to Iman? I hand over to Michel now. Michel.
Merci Madame la Présidente. Eh bien, une fois n'est pas coutume, nous commençons exactement à l'heure, puis c'était prévu à 12h10. Dans le pays de l'horloge et de la montre, ce n'est pas un luxe. J'ai le plaisir de présider ou de modérer cette table ronde. J'aimerais d'abord remercier Terre des Hommes par M. Bouetton de m'avoir associé à cette magnifique manifestation internationale. Ça me donne le plaisir de rencontrer plusieurs amis, puisque je bourlingue aussi un petit peu le monde depuis plus de 30 ans maintenant. Et j'ai l'honneur donc de modérer cette table d'experts dont les intervenants sont au cœur de l'idée des réformes législatives. Et chacun d'eux a une particularité qui lui est propre. Et je vais la donner tout à l'heure en leur cédant la parole. Le thème de la journée est de renforcer le système de justice juvénile. Alors, doit-on renforcer ces systèmes? Doit-on les modifier? D'après ce qu'on a entendu, les bons résultats dans les différents pays, il semble que cela soit justifié. Mais comment s'y prendre pour renforcer, pour modifier ces systèmes juridiques? Alors, j'ai la chance de compter auprès de moi sur 3 personnalités venant de 3 régions différentes, bien différentes, puisqu'on a un représentant de l'Amérique latine, un représentant de l'Asie et une représentante de l'Europe, une compatriote. La représentante de Jordanie, Madame Tagrid Jaber, n'est pas là. Donc nous allons procéder avec les 3 intervenants précités. Ces 3 personnes ont toutes 3 des atouts très importants dans leur jeu et on se réjouit évidemment de connaître leurs cartes. Je présente tout d'abord, et je vais donner la parole au docteur Armengol Kwara Lopez. Monsieur Kwara Lopez est président de la Cour suprême du Nicaragua. C'est un juge de très grande expérience et une personnalité déterminante dans son pays pour les réformes législatives. Il vient d'un pays, le Nicaragua, qui n'a pas des moyens extrêmement importants, mais justement, avec peu de moyens, on peut aussi faire beaucoup. Et Monsieur le juge est une personne qui a mis en place beaucoup de structures innovantes. En particulier, il est un des pionniers de la justice restauratrice. Monsieur le Président, je vous cède le micro.
Buenas tardes a todos los delegados aquí presentes. Acerca de las leyes y procedimientos, queríamos referirnos a nuestro Código de la Niñez y Adolescencia vigente desde el año 1998. Señala una justicia especializada para el tratamiento del joven en conflicto con la ley, el cual contiene varias opciones de soluciones como la mediación, la conciliación, libertad condicional y sobre todo medidas alternativas socioeducativas, de orientación, de apoyo familiar, libertad asistida, prestación de servicio a la comunidad, reparación de los daños a la víctima, medidas de orientación y supervisión que comprenden instalarse en lugares de residencia determinados, prohibir visitas a bares y discotecas, matricularse en centros educativos, inclusión de programas ocupacionales, entre otros. Acerca de las medidas privativas de libertad, comprende privación de libertad domiciliaria, privación de libertad durante el tiempo libre y privación de libertad en centros especializados como última medida, con evaluaciones periódicas para el cambio de medidas. Todas estas oportunidades se fundamentan por tratados internacionales, convenios, reglas y sobre todo a la Convención sobre los Derechos del Niño, instrumento internacional suscrito, aprobado y ratificado por Nicaragua en 1989, vigente en nuestra Constitución Política de Nicaragua en su artículo 71. De esta manera existen garantías judiciales y de respeto a los derechos humanos del niño, el debido proceso, el acceso a la justicia contemplado en el Plan Decenal del Poder Judicial de Nicaragua. El joven o adolescente participa en todas las etapas del proceso judicial, lo mismo que los padres, tutores, defensores y la víctima. Nuestros funcionarios judiciales, jueces, están debidamente capacitados y especializados. Tienen disposición al trabajo, conciencia, dedicación y responsabilidad al aplicar la ley, de una manera justa y tomando en consideración al joven en su fase de desarrollo físico y mental. La capacitación continua de nuestros funcionarios judiciales y administrativos es fundamental para la debida administración de justicia, apoyado de manuales de procedimientos elaborados en consenso con todos los operadores del sistema de justicia juvenil. De todo lo que se ha hablado en este Congreso acerca de las leyes y procedimientos, Nosotros consideramos, y así lo hacemos en la práctica, que para elaborar leyes y procedimientos se necesita la voluntad política, consenso, participación de toda la comunidad, la sociedad, instituciones estatales, coordinación con las instituciones de los operadores del sistema, Poder Judicial, Fiscalía, Policía, Sistema Penitenciario, en fin, todos los involucrados en los procesos de los jóvenes. Debe existir conciencia, compromisos, responsabilidad de todos los actores sociales de la sociedad en general. Contamos con el apoyo de organismos internacionales y organismos no gubernamentales como UNICEF, Tierra de Hombres y otros. Asimismo, tenemos convenios con las alcaldías, centros de educación, centros técnicos donde los jóvenes se capacitan, estudian y preparan en conocimientos técnicos, soldadura, mecánica, electricidad, etc. Con estas medidas se han bachillerado, han llegado a la universidad y han finalizado carreras técnicas jóvenes que han estado en conflicto con la ley. Otra novedad es que contamos con el facilitador judicial, una figura creada por la Corte Suprema de Justicia, que es el líder de la comunidad que apoya los conflictos de las personas y soluciona y busca soluciones para que esto no llegue a la vía judicial. Esto ha sido de mucho beneficio para Nicaragua. Nicaragua apuesta por la prevención y seguridad ciudadana. Por tal razón, el Informe Regional de Desarrollo Humano 2013-2014 señala que Nicaragua se encuentra entre los 6 países que reflejan mejores indicadores de seguridad ciudadana en América Latina. Este informe analiza a profundidad el fenómeno de la seguridad ciudadana, estudia experiencias exitosas y propone recomendaciones concretas para mejorar las políticas públicas. Resalta además que una de las principales lecciones aprendidas en la región centroamericana es que las políticas de mano dura no funcionan. La fuerte represión policial y penal a menudo ha coincidido con alto índice de criminalidad. En ese sentido, el Estado de Nicaragua no ha trabajado con políticas de mano dura, o mano superdura o tolerancia cero, sino, por el contrario, ha implementado políticas de prevención y aplicación de justicia con enfoque restaurativo que incide en el bajo nivel de reincidencia, que tiene como fundamento la Constitución Política, el Código de la Niñez y la Adolescencia, leyes nacionales, convenios internacionales, así como el Plan de Desarrollo Humano. La justicia restaurativa en Nicaragua, la autoridad de funcionarios e instituciones públicas involucradas, hemos entendido que el enfoque restaurativo, aquel que considera la problemática del delito y el principio de responsabilidad del adolescente infractor, haciéndole consciente del daño o lesión de derechos individuales o colectivos derivados de la acción, abordado desde una visión educativa y pedagógica, no solo punitiva, que considera el respeto a los intereses legítimos de las víctimas, evitando la revictimización y haciéndole partícipe en lo posible en la solución de efectos negativos derivados del delito, que considera la reparación directa o indirecta del daño causado como parte principal del trabajo con los adolescentes infractores. En este proceso, la Fundación Tierra de Hombres, desde julio de 2006, decidió apostar a la construcción de un proyecto en Centroamérica desde Nicaragua, que permitieron la realización de 3 seminarios de justicia juvenil con enfoque restaurativo, 2007-2008, logrando capacitar a nuestros operadores y resaltar nuestro marco legal del enfoque restaurativo. De esta manera se propuso generar normas y protocolos de procedimientos basadas en el análisis sincero y honesto de la realidad y en la propuesta de lo que realmente debía ser la intervención con adolescentes en el sistema penal. Como producto de esa iniciativa surge el acuerdo de sala número 68 de la Corte Suprema de Justicia, Sala Penal, procedimiento para la ejecución y vigilancia de las sanciones penales de adolescentes o jóvenes, que es un auténtico procedimiento milimétrico sobre la actuación de cada operador en la fase de ejecución de las medidas no privativas de libertad, acuerdo que vino a consolidar una nueva práctica completamente diferente. Cada operador, cada psicólogo, trabajador social, jurista, define su intervención con el propio adolescente, la familia, con los centros y servicios de la comunidad, implicados con la propia naturaleza de la medida y con las víctimas. El acuerdo de sala regula fundamentalmente la asignación de funciones, los protocolos y procedimientos que deberán cumplir las oficinas de ejecución y vigilancia, así como los procedimientos referidos a la coordinación entre los órganos judiciales y los centros de servicio de ámbito social, educativo, terapéutico, públicos, privados presentes en la comunidad, en los cuales los adolescentes ingresen a cumplir las distintas medidas impuestas por los jueces. Este acuerdo fue elaborado por autoridades judiciales a nivel nacional y asesorado por expertos internacionales, con el doctor James Sarmatén, Víctor Herrero y licenciado John Orlando, en el marco de convenio de colaboración del 2008 con la Corte Suprema de Justicia y Tierra de Hombre. Esto ha permitido homologar en todo el país un modelo de gestión de todas las medidas y ha producido efectos muy positivos, entre otros: seguridad jurídica respecto de los derechos de los adolescentes, cumplimiento efectivo de las medidas, implicación de los servicios a la comunidad, mínima incidencia en el cumplimiento de las medidas impuestas, reintegración del delito y, por lo tanto, genera una máxima confianza en los procesos judiciales para primar las medidas no privativas de libertad sobre las privativas de libertad. Actualmente, de los 756 adolescentes responsabilizados penalmente, 548 están cumpliendo medidas alternas a la privación de libertad y 208 únicamente están cumpliendo medidas privativas a nivel nacional. De 6 millones de personas, de habitantes que tiene Nicaragua, y el 60% que son jóvenes, apenas tenemos 208 a nivel nacional. Para concluir, Nicaragua en los últimos años no ha apostado a cambios en su ley ni reformas, ni apuesta por aplicar políticas de mano dura, sino en la prevención y consolidación de los mejores principios y valores ya existen en nuestras leyes y que son coincidentes con los principios de justicia restaurativa. En Nicaragua el tratamiento ha sido diferente respecto al contexto de Centroamérica y América Latina, y este Congreso es un espacio privilegiado para compartir las experiencias entre los países. Nicaragua comparte esta experiencia que se está demostrando positivos resultados, tanto en materia de seguridad ciudadana como intervención con adolescentes infractores, y propone a los responsables y funcionarios públicos presentes evitar las tendencias retribucionistas de resultados negativos para los adolescentes. Agradezco a la invitación de Tierra de Hombre y en especial a Carmen de Felice, delegada por Nicaragua. Muchas gracias.
Merci, Monsieur le Président. Je trouve absolument remarquable ce qu'on peut faire avec peu de moyens pour cette justice juvénile spécialisée. Je vous félicite et j'espère qu'on pourra approfondir dans les ateliers, notamment les contacts que vous avez avec les politiciens. Vous nous avez dit que les politiciens vous soutenaient beaucoup. Dans les pays, c'est en général assez difficile. Il faut avoir des contacts précieux. Merci. Je passe maintenant la parole à l'honorable juge Mohamed Iman Ali. Monsieur le juge vient du Bangladesh et nous l'avons déjà entendu hier matin. Monsieur Ali est juge à la Cour suprême. Il est de religion musulmane. C'est une personne très croyante, très pratiquante et qui est engagée. C'est important de le relever parce qu'il est en même temps très ouvert à tout ce qui se passe dans l'international. Notamment, il est très ouvert et convaincu par les lois et règlements internationaux. Alors, honorable juge, expliquez-nous comment vous arrivez à concilier ces éléments qui, pour d'aucuns et de prime abord, sont inconciliables ou difficiles à mettre ensemble et qui, pour d'autres, sont tout à fait stimulantes, comme vous l'avez fait dans votre pays. Vous avez la parole.
Thank you very much. Good afternoon to everybody again. I'm not a juvenile justice judge. I'm not a magistrate. And I think you would imagine that, can I be dealing with children's cases? The answer possibly is no. Simply because normally children's cases do not come to the higher courts. But I can tell you, where there is a will, there is a way. In 2006, I realized that we had in our country a very old law of 1974, a very good piece of legislation. And in 2006, I found that that legislation was unknown in a particular case to the judge, to the lawyers, to the prosecutor, to all and sundry who were dealing with that particular case. And that I found to be very strange and challenging in the sense that I then wanted to tell everybody that children have to be dealt as if they are children and not adults. I then went on a spree of dealing with other aspects of children's justice and somehow managed to, in my time at the High Court Division, deal with, I think, 12 or 13 cases relating to various aspects of juvenile justice and rights of children. Why am I telling you all of this? Simply because I believe it is possible, if you want to do justice for children, to do so. But then on the other hand, as I said yesterday, we here are the converted and there are a few more outside, but the rest of the world is totally against children, particularly children who are ill-behaved, termed as delinquent or offenders. They are marginalized, they are stigmatized, and they have to be dealt with severely in order to teach them a good lesson. Now, I have been able to manage to bring awareness to our judges, to all those in the community who are involved with children, in my own way, aside from the work that I have been doing as a judge of the Supreme Court. I have been lecturing, training judges, prosecutors, lawyers, and others, both in Bangladesh and abroad, only to bring the one simple issue to the fore, and that is that children have to be dealt with differently. The laws of every land will cover the rights of children as they do for adults, because the children are also citizens of each country, the relevant country. But that does not mean to say that the children have to be dealt with like adults. In fact, rather the opposite. Children have to be dealt with as children and not adults. And we all know why. The answer is very simple. Children are not developed mentally, physically, and not capable of discerning what is right and what is wrong absolutely at the moment when they do something which we feel is wrong. And that is why we need to tell others, our colleagues, our friends, and relatives who treat their children, own children well, but do not like the others, the children of others, as much as they love their own. That is why we need laws. Now, the laws relating to children, many of you are lawyers, many of you judges, all well aware of rights of children. Now, rights of children hasn't simply dropped from the sky overnight. It has developed over a century and a half. And it will develop further, because our views of how we treat our children, our adults, our citizens will change from time to time. What we need to concentrate on, particularly when we are dealing with the rights of children, is the mindset of adults, because that is where children are falling foul. They are not getting what they deserve simply because we do not treat them in a way that we should. We find that even in developed countries, such as the United States and the UK, children who do acts which are rather more serious than everyday petty offenses suddenly become adults. A child who inadvertently or knowingly, intentionally or unintentionally, injures someone severely, even kills someone perhaps, suddenly becomes an adult. A 12-year-old, a 14-year-old, a 15-year-old who commits a serious offense, does he cease to be a child? The answer is, in my books, certainly not. Does he deserve to be treated as an adult and dealt with as an adult in an adult court? Answer again is certainly not. And I would say perhaps that that child needs more protection than the other children who are committing perhaps minor offenses or committing no offenses. Because that child needs help. He has done something wrong, obviously, but we have to show him, we have to tell him, we have to teach him that what he has done is not right. He must not do it again. We have to make him appreciate that what he has done has hurt someone else, and that he should mend his ways. And we have to help him to mend his ways. The other thing that we must always keep in mind is that the children who are before us in the courts, they're not like your and my children. They have not had the benefit of the good upbringing that your and my children have had the benefit of. We advise our own children how to behave well, how to do good things, how not to hurt others. But those children who come before us as offenders, sadly they do not have the benefit of advice, good advice from parents. They do not have the benefit of getting the things they need in life most because of their poverty, because of the inability of the parents to fend for their children. Now, let's go to reforming the laws. You find a good NGO, supporters who will help you to create laws, like I did in 2006. When I found that the existing law was unknown, I decided to recommend that new laws must be promulgated, or at least the laws which are there must be amended in order to incorporate the provisions of the CRC. And UNICEF, thankfully, jumped and said, we will help. And the ministry, again very thankfully, said, we want to change our law and bring it in line with the international norms. Great. It took 7 years for the law to come into force. But then having done that, am I any better off? Are the children in Bangladesh any better off? The answer is no. At this moment, no, because the law needs a lot of peripheral activities to be done in order to make it active, to be implementable. We need a lot of infrastructural developments to take place before the provisions can be activated. We need rules which will enable us to implement for example, the diversionary provisions, the alternative dispute resolution provisions, and so on. We also need huge funding from the government. This is where the government will is essential. So far, we have had good response from our government. They have been very supportive. But, as our President said only a few weeks ago when I went to meet him for something, we don't have the resources to provide the things that I have asked in my judgments. I asked very simply that we must have a child care center. If we must keep children in detention, they must be kept in a proper center where they can get further education, where they can get the benefits a child would get, rather than the benefits, or not so much of the benefits, that adults get in the prisons or the detention centers. In one of my judgments, I said we need at least one of these centers in every district, because otherwise the parents are saying to the judge, please send my child to the local prison so that I can go and visit him. That's illegal, but that's what they're asking for. So when I say we need centers to keep the children in every district so that the parents can go and visit them, can we manage it? The answer is, at this moment, it seems like we cannot, because we don't have the resources. The other thing that we must remember is that you can perhaps get laws enacted pretty quickly, but then you have to make sure that the laws are relevant to your own countries, to your citizens. I give you just two examples. In our exuberance to give all the benefits to all the children of our country, we said that wherever a child is involved in any activity which takes them to court, they must be dealt with by the Children's Court. Sounds very fine, but it's impractical, because as a result of the law, and somehow it escaped my notice when it was being drafted, what has happened is that a murder case where a child is simply a witness has been channeled to the Children's Court. Now that is impractical, because you cannot have all murder cases where there's a witness child to come to the Children's Court. Equally, where the child is a victim, we have separate courts, specialized courts to deal with women and children who are victims of crime. Those have automatically been channeled to the Children's Court. Again, I think that is impractical. I'll give you another example where we had recently the Violence Against Women Act. Now, I was talking at the time before it was being drafted of my experience in England in 1970, mid-70s, when the Domestic Violence Act was being enacted in England. And there, we wanted to exclude the husband from the matrimonial home. And we did that simply by an exclusion order from the court. And in 2013, or 12, I can't remember which, we have said the same thing in Bangladesh. We will exclude the husband from the matrimonial home. But then in Bangladesh, we don't have only the husband in the house, we have his mother, his father, his brothers and sisters, they're all in the house. What do we do with them? So it has to be relevant. It has to be practical. We have to make sure of that. Why do we need laws at all separate for children? Because our judges sadly have to be taught what we need or how we need to deal with our children. As I said yesterday, not all the people outside are child sensitive or child friendly. The lawyers, we had cases where lawyers were applying for bail for 8, 9, 10-year-olds who had been caught with drugs, in possession of drugs. They are not criminals. They cannot be prosecuted. In our law, up to the age of 9 or between the age of 9 and 12, they cannot be prosecuted. Even if they kill someone, they can't be prosecuted. But here we had a case where they had been arrested, taken to court, taken to the magistrate, taken to safe custody in a jail. It was all wrong. The lawyer applied for bail. That's all wrong. You don't apply for bail when there is no prosecution possible. So we do need laws. We do need laws so that we can make people aware of what the rights are. Whenever we talk of change in the policies, change in the laws, we must always bear in mind the possibility of implementing the provisions that we are introducing. It is no good just making laws for the sake of making laws. You have to be realistic. You have to be able to say that, yes, this will be for the benefit that we want to achieve. Now, the chairman has kindly given me something else to talk to you about. I'll just very briefly talk about it. And that is whether we should have specialized judges. The problem that I believe she is referring to is if you have specialized judges, then there is no way up. The magistrates who deal with only children, there's no prospect of perhaps promotion. But then I remember many years ago reading about an American judge in a children's court. I believe his name was Thomas. He had been a children's judge for, I understand, 40 years. But he was such an expert that every time anybody wanted to do anything to do with law on children, they said, this law, did Judge Thomas approve it? If he didn't, then it can't be good law. If he did, then it's definitely good law. So that was Judge Thomas. Can we aspire to be that? Would we want to? I would, certainly. I don't care if he's just a magistrate or a lowly judge in a small court somewhere out in the outbacks. If he's doing something good, he should be there. Have I had my time? I think I have had my time.
Fini.
Thank you very much for your attention.
Merci, merci, chers collègues. Les lois disent tous les enfants sont égaux devant la loi. Or, vous avez bien relevé que les enfants n'avaient pas tous la même situation, n'avaient pas tous la même éducation. Et c'est vrai, et ça c'est important de le relever. Et c'est bien pour cette raison qu'il faut former, informer tous les professionnels du travail. Je vous remercie pour votre témoignage et je vais donner la parole tout de suite à Madame Christina Weber-Kahn, qui est donc, comme je l'ai dit tout à l'heure, une compatriote. Elle vient de Suisse, qui se bat depuis longtemps pour améliorer le système judiciaire. Alors, Madame Weber-Kahn dirige, avec d'autres personnes, le Kinderanwaltschaft, qui est une association qui regroupe plusieurs avocats. C'est assez spécial et j'aimerais bien qu'elle nous en parle un petit peu, parce que l'avocat d'ordinaire, c'est une personne indépendante qui défend son client, qui parfois perturbe un peu la procédure ou l'allonge pour gagner un peu plus, et puis qui n'est pas souvent spécialisé. Ben, on peut le comprendre parce que personne ne va le payer lorsqu'il se forme et prend des cours. Et alors, avec le système que met en place Madame Weber-Kahn, il semblerait que plusieurs avocats vont se spécialiser, vont se regrouper et pour défendre les jeunes en contact avec la loi. Madame Weber-Kahn, je vous donne la parole.
So, thank you very much, and I would like to thank in the name of Kinderanwaltschaft, I would translate that with child advocacy, for the invitation of this highly interesting and inspiring Congress. Just to make a short clarification to what Mr. Lasha said, my professional background is social worker and I am specialized in children's rights. So my colleague is here she is a lawyer and she works with the legal representatives and the lawyers, which are also part of our organization. The topic of the agenda today is strengthening the juvenile justice system, and in my presentation I focus on the procedures and less on the juvenile justice law that already presented Mr. Stadelmann from the Federal Office of Justice. And in my short presentation, I would like to address the following 3 points. The guidelines on child-friendly justice of the Council of Europe, which are already presented yesterday by Mrs. Regina Jensdottir from the Council of Europe. And then I would like to come to the point, what are the added values of the guidelines for the juvenile justice system? And then shortly present you the program Child-Friendly Justice 2020 from Kinderanwaltschaft. We are convinced that the application of the child-friendly justice guidelines leads to a substantial improvement in the whole justice system for all actors, and on first hand for the children and their families. But all other actors, which were mentioned in this Congress several times, the police, the prosecutors, the social workers, the legal representatives, the judges, but also for professionals in law enforcement. As already Mrs. Jensdottir introduced yesterday, the guidelines had been adopted by the Committee of Ministers in 2010. And what I think is really remarkable about these guidelines is that in the drafting process were also children involved, and their views on justice systems had been included in these guidelines. I really think this is a special legitimation also for these guidelines. And the guidelines are intended for use by professionals working with the criminal, civil or administrative justice system. It's not limited on just one part of the justice system. And the guidelines also build the framework of our work, how you will see afterwards. The scope and the purpose of these guidelines is to ensure in any procedures that all rights of children, among which the right to information, legal representation, participation and protection are respected. And these guidelines cover all stages of the proceedings, and as also Mrs. Renata Winter emphasized before, I think this is very important to keep always these 3 steps in mind and to be aware where we are, what we have to do and what can we do. I just stress a few points. Information and consultation of children is crucial, and alternatives to judicial procedures as mediation, family group, conferences, etc. should be approved. During that, a legal representation and counsel is installed if necessary, and the right to be heard and to express their views, avoiding undue delay, and what is very crucial, I think, is a child-friendly environment and language. After one important point is to communicate the decision in a child-friendly language. If we look at the decisions which we hand out towards children or also to their parents, not even the parents understand really what is written in there. So for a legal representative, very often it is the job to translate the decision, what had been taken, and it would be also very good, and in the juvenile justice system, it is very often that the judge is at least also explaining the decision which had been taken, but in administrative proceedings or in family law proceedings, sometimes not. And the last point, to enforce judicial decisions without delay. So what are the added values of the guidelines in the juvenile justice system? I would like to start with the point, what are the added values for children specifically? And it is to strengthening children and juveniles in a difficult period of their life. And I think this is a really crucial, important point. And I would also like to refer to Judge Tomonu from yesterday from New Zealand. I was very impressed by his presentation, and especially also that he stressed out the process is as much important as the outcome, and we focus sometimes too much of the outcome. These are cases we have to go through, and I think the process which children are involved strengthens then if it is well done. And also the second point is we know that from the field, and I also had been working in the field, so it is a better cooperation of the children and juveniles through participation. Participation makes field children respected, they feel taken serious, and they are part of the solution, and that makes also decisions gives decisions a different ground and different legitimation. But what the added values are for the professionals, we talked much about the professionals. I don't want to go too much into it. But one point I would like to highlight, professionals are confident in the work with children through specific trainings in child development, in the dialogue with the child, etc. I mean, this was highlighted out so many times during this conference. But I would also like to come to stress the last point, what is the added value for the system? And the added value for the system, if you work with guidelines, with standards, is that you establish consistent procedures, and this in regional and nationwide. It doesn't mean that it is completely streamlined and it's just like this how you do. It has local differences, but I think it should be, it's also a right of the child that it is not depend on where and who is the judge and where is the court. It should have a guarantee of minimal standards in a proceeding. And this is what I already mentioned, to set standards, how to work with children and their families. I come now to the point how we do that. In Switzerland, we are in a process to implement a child-friendly justice. Kinderanwaltschaft, as an innovative NGO, is striving to achieve a child-friendly justice by 2020. And to achieve this goal, we are convinced that it needs a change in the whole system. Therefore, it is crucial to work in the following 3 areas at the same time. With children and juveniles who are concerned in any procedure, they need to be informed and consulted. I can just give you an idea. In 2014, we had 550 consultations. People called us or wrote us via mail, and it was about 269 families with 376 children. And we, at the moment, as you probably know, Switzerland has 3 regions, and at the moment we just work in the German part of Switzerland, so it's not representative for whole Switzerland. And actually, we need in Switzerland an ombudsperson for children who are involved in the justice system. This is something we are lobbying on a political level. And the second wheel, if you want to say like that, to work with professionals in courts and administration. It was also mentioned several times in this conference. And what we do is that we work with partner courts and authorities. So we are in a dialogue with them. We introduced the child-friendly justice guidelines. I did a kind of an analysis. It was in the family law and in the child protection law, in the juvenile justice law, not yet. But in other procedures, we did an analysis how they respect or how they are in the line with the guidelines. And then we were discussing about what do they need on the first hand, what kind of practical tools they need that it is easier to follow these standards. And on the other hand, then the next step is, of course, with good practices, with professional trainings and quality management. And the third point, which Monsieur Lachat mentioned, is we work also with qualified legal representatives for children through qualification and training. So it's not that we do that. We work with existing partners, with universities, with other specialized institutions, that they provide special trainings trainings. For example, we invented with the University in the of Social Work in Lucerne. It is a certificate of advanced studies for children representatives. Two minutes, okay, good. Okay, so, and to come really to this point, we were also asking ourselves how we do that, not only what we do, and this is it needs a change on all levels. And just to come quickly to these three levels, as you see, the first level is about knowledge about the CRC and the child-friendly justice guidelines. We disseminate this information to all stakeholders. And we do this via our website, newsletter, media, leaflet, and children we approach also via social medias in the next time. It needs tools for implementation. It needs tools in the daily work that you can really that you have checklists, that you have best practices. For example, of a child-friendly environment and setting, how does that look like? What are the ingredients that children feel fine? It needs qualification and trainings for professionals. It needs video training for professionals for hearing of children. About the child development, about the dialogue with the child. I don't have to add more trainings. It was exhaustively, we heard about that. And the fourth level, which is I would say the most delicate, Chachi Mamali mentioned it with the mindset. It's the inner conviction, it's attitude that the child-friendly procedure is in the best interest of the child and is strengthening the child. And in this way, I would like to come to the conclusion that therefore a child-friendly justice system leads to a substantial improvement in our work with children in the justice system. And I hope after 2020 we can give you some results what changed in the system. Thank you very much for your attention.
Merci beaucoup, Madame Weber-Kahn. Tout un programme, un beau programme. Je vous souhaite de réussir et je me réjouis aussi de voir les résultats. On est dans les temps, comme je l'ai dit d'ailleurs au début de l'introduction, mais permettez-moi de poser encore une petite question. C'est un peu le vœu des organisateurs. Nous avons la chance d'avoir l'honorable juge Mohamed Iman Ali et j'aimerais lui poser cette question qu'il va répondre en 2 minutes. Quel rôle la religion, puisque je vous ai dit que c'est un homme très engagé, quel rôle la religion a joué ou joue encore chez lui et dans sa façon de concevoir la justice juvénile?
It's my lucky day. I get bonus time too. Now, Monsieur Lachar has, I think, expressed the view that I'm very religious and I know a lot about the religion. Sadly, I have to admit that I'm not so familiar with the Islamic laws as perhaps some of my brothers and sisters from the Muslim countries here are. But so far as I understand, the Quran and the Sunnah does not make it a right that children should be badly treated. On the contrary, as far as I understand, the Quran and Sunnah says that the rights of the children have to be what's the word? Protected. And the rights of the child starts even before the child is conceived. The Quran tells us that the choice of the bride, the pedigree of the bride is important because that's where the good children come from. And it goes on to say that the children should be treated with love, given education and guidance. Yes, they have to be disciplined, but there is nowhere where it says that they are to be chastised or corporal punishment is to be imposed upon them. So, we have in our world, in the Muslim world as well as others, where children are very badly treated, beaten in schools, in the houses, in the homes. I believe there is no law of any religion which allows for that. Certainly the civil law of every country protects every other citizen from being beaten by another citizen. If I were to punch someone in the nose, I would be quickly taken up by the police and held up for assault and battery. When a child is beaten up in a school, nothing happens. Now that has nothing to do with religion. That is, again, as I said yesterday, the mental attitude that we have towards children. The macho attitude that we have because we are stronger, because we are bigger, because we are more powerful. So I would conclude by saying that my personal view is that the religion does not have any barrier, does not create any barrier for giving the benefits of everything that we can give to our children. On the contrary, the Muslim religion, as far as I understand it, ordains that children must be protected, must be loved, must be educated, and must be given guidance. Merci.
Merci beaucoup, Monsieur le juge, pour votre témoignage. J'aimerais remercier aussi les 2 autres intervenants pour leurs propos et les programmes qu'ils ont mis en place. Je cède définitivement la parole à la présidente pour clore cette matinée.
Thank you, Mr. Olesha. I am now about to say thank you to all of you for your patience and thank you to the speakers, thank you to the panelists. I need to hand over to Mr. Poutant for giving you the logistical information, and from my side, thank you for being such a patient audience and giving us your time. Thank you very much.
Yes. Ladies and gentlemen, before going for lunch, I would like to give you some practical information, as I did yesterday, to say which room number for each one of the workshops available this afternoon. And yesterday it was perfectly running. There was only 5 or 6 people who were completely lost, which is not bad at all. Well, so if you can write on the program the workshops of this afternoon, you have 6 workshops from 2:30 to 4:30, and I give you now the room number for each one of these workshops. The first one is workshop number 3, Juvenile Justice System Reform. It will be room number 2. The room number 2 is the big one, which is downstairs. This workshop will be translated into French, English, and Arabic. The workshop number 4, Protection of Child Victims, Survivors, and Witnesses. Room number 1, which is that room, this room where you are now. This workshop will be translated into French and English. The workshop number 5, Juvenile Justice in Relation to Migrant Children. It will be in the room number 3, translated into French, English, and Spanish. The workshop number 6, Data Collection and the Use of Statistics. Room number 4, translated into French, English, and Russian. The workshop number 7, Sensitizing Public Opinion on the Principles of and Practice of Juvenile Justice. Room number 18. It will be translated into French and English. The workshop number 8, The Gender Perspective in Relation to Juvenile Justice. It will be in room 5 and 6. It's a common room. And this workshop will be translated into French and English. After the workshop and the list of workshops I gave, you have to choose one of them because they are all at the same time in the different rooms. After that, we have the pause. And after that, we have some exceptional side event. The first one is organized by the CRIN, which is Child Rights Information Network. And we will have the pleasure to listen to Professor Sergio Pineiro, with the title of the conference will be Stop Making Children Criminals, the Minimum Age Debate, Separating Responsibility from Criminalization. This session will be only in English without translation. Of course, there will be a presentation by Professor Pineiro, but then there will be a debate. From 4:45 to 6 o'clock. It will be in room number 2, the big room which is downstairs. Immediately followed, in the same room number 2, by the presentation of a film on juvenile justice. Pete qui la pellicola. I don't know if my accent is good. So it will be introduced by Mr. Mario Hemmerling from UNODC. UNODC having co-finance, the production of this film. It's a film about the violent gang of minors in Central America. The film is in Spanish and subtitled in English. Then there will be a debate, and there will be a translator between Spanish and English. And I want to thank the translator who will attend this side event because the interpreters offered free of cost to cover the translation of the debate after the film. The debate will be about 20, 30 or 35 minutes. And thank you for the interpreter. Then the third and last side event today is a special conference, debate, meeting with the judge, police, and social worker of the city of Geneva. So we thought that for the French-speaking congressists, French-speaking participants, that would be interesting to have a dialogue with the judge, the police, and the social worker of the city where this Congress happens. So all French-speaking participants are most welcome tonight from 8 to 9:45, exactly in the same room, also room number 2, which will be downstairs. So thank you very much, and I would like to say people who have a blue badge, this badge, people who have the blue badge, for lunch you are invited to attend the restaurant room, which is in the hall. Sorry, the film will be also in the room number 2. That means the 3 events after the workshop will be in the same big room number 2 downstairs. So the blue badge are welcome, are invited to join the restaurant in the hall. Thank you and have a good lunch.
Like our stuff here again?